Protecting intellectual property is a critical part of developing a strong business plan. In this module, I'll focus on how to safeguard the ideas, inventions, and brand assets that give a business its identity and competitive value. The key principle is to protect these assets before competitors can capitalize on them. We'll consider why intellectual property matters strategically and how thoughtful protection can support a business's long-term growth, credibility, and market position. Intellectual property is often one of a company's most valuable assets, yet it can be overlooked during early-stage planning. Unprotected IP can be copied, stolen, or independently developed by competitors, weakening your advantage very quickly. Strong IP protection creates a competitive moat by establishing barriers around your market position. It also builds investor confidence because documented IP provides evidence of enterprise value. Finally, IP can become a revenue stream in its own right, especially through licensing agreements that generate income beyond the company's core operations. Intellectual property protection rests on four complementary pillars. Patents protect inventions and novel processes, giving their owners exclusive rights to make, use, and sell them for a limited period. Trademarks protect the names, logos, and slogans that help customers recognize a brand. Copyright covers original creative work, including writing, software, music, and art, beginning when the work is created. Finally, trade secrets protect valuable confidential information, such as formulas, processes, and strategies, by keeping it secret and controlling internal access. Together, these protections cover innovation, identity, creativity, and know-how. Patents protect inventions by granting rights over specific innovations. There are three main types. Utility patents cover new processes, machines, or compositions of matter. Design patents protect a product's ornamental or aesthetic features. And plant patents cover asexually reproduced plant varieties. A provisional patent application establishes a priority date and gives you 12 months to refine the full filing. To qualify, an invention must be novel, non-obvious, and useful. Plan for prosecution to take 2 to 5 years. Involve a registered patent attorney, and include your patent strategy in the business plan's IP section. Trademarks help protect the elements that make a brand recognizable and distinct. They can include business names, logos, slogans, taglines, product or service names, and even distinctive colors, sounds, or packaging. There's also an important difference between common law rights and federal registration. Using the symbol signals that you're claiming a mark, even if it isn't registered. Once the mark is federally registered with the USPTO, you can use the symbol, gaining nationwide legal protection and a presumption of ownership. Registration provides a stronger, more enforceable position. This slide covers two forms of intellectual property protection: copyrights and trade secrets. Copyright protection arises automatically when an original work is created and fixed in a tangible form, including software, websites, marketing materials, and manuals. Registration is optional, but strongly recommended because it can unlock statutory damages in an infringement lawsuit. Trade secret protection lasts only as long as secrecy is maintained. That means organizations need active safeguards, and under the Defend Trade Secrets Act, misappropriation can lead to significant civil damages. Protecting intellectual property daily depends on practical agreements, not just good intentions. First, use non-disclosure agreements before sharing proprietary information with employees, contractors, partners, or investors. Choose a mutual or one-way agreement based on the relationship. Second, employment and assignment agreements should clearly transfer ownership of work created during the engagement to the company. Third, non-compete and non-solicitation clauses can help limit competition and client poaching after someone leaves. Because these restrictions vary significantly by state, legal counsel should review them before you rely on them. A proactive IP strategy helps protect and build business value throughout the company's growth, from seed funding through exit. Investors want to see three things clearly. First, an IP inventory, a complete view of proprietary assets and how each one is protected. Second, an understanding of the competitive landscape, including evidence that the IP is differentiated and that the business has freedom to operate. Third, an enforcement plan that explains how the company will respond if others infringe. Together, these elements show that IP is managed as a business asset, not an afterthought. When a business plans to enter global markets, filing domestically is not enough. IP rights are territorial, so protection in the United States does not automatically extend to other countries. International strategy matters. For patents, the Patent Cooperation Treaty, or PCT, provides one international filing covering more than 150 countries and gives applicants time before entering national phases. The Madrid Protocol simplifies international trademark registration through a single WIPO-administered application. For copyright, the Berne Convention provides automatic recognition across more than 180 member countries without requiring separate registration in each one. Intellectual property infringement can take several forms, so recognizing the situation quickly is essential. Examples include a competitor copying a patented product design, a confusingly similar trademark, unauthorized online use of copyrighted content, or a former employee disclosing trade secrets. Your response should match the type and seriousness of the violation. A cease and desist letter is usually the first, least costly step. For online copyright issues, a DMCA takedown may help. Trademark disputes may involve USPTO opposition or cancellation, while federal litigation is reserved for cases where significant value is at stake. The key takeaway is that IP protection is an ongoing business discipline. Know your assets, choose the right protection, and use agreements from day one. Think globally when needed, and integrate IP into your business plan to strengthen investor trust and competitive advantage as your company grows.